Hello again. As you know, I'm Bob Wisniewski, and we're now at the part of your case where we're going to discuss what is a deposition. In every claim, the other side has the right to require you to go in front of a court reporter that will take down your testimony and type it into a booklet. The reason for that is to allow the other side to know exactly what your testimony will be. We have provided you a information sheet, and the other side has provided us a notice of a deposition. That means you and I are to go to the other lawyer's office to answer these questions. What I'm going to try to explain to you today is what I would tell you in person, and after this videotape is over, I want you to write down any questions that you might have about the process and ask me those questions, and then I will attempt to give you some additional tips about the deposition. What I tell people in a deposition is to always tell the truth. It's difficult for me to say don't be nervous because I've been to and I've taken thousands of depositions, and the likelihood is this is your first deposition in front of the court reporter. There will always be a translator if you don't speak your English, and then what I always tell people, no matter whether they speak English or another language, is listen to the question that the other lawyer is asking. It is not your opportunity to tell your whole story. The deposition is not the Industrial Commission Workers' Compensation hearing, and it doesn't take place instead of the hearing. So people think, oh, I went to my deposition, I don't have to tell the judge about my case. I tell people sometimes to think of the deposition as perhaps practice for the hearing. In the deposition, there will be the other lawyer. There will be perhaps a representative of the insurance company. There may even be one of their experts if this deals with a later part of the case and it is the loss of earnings as a result of the compensation claim. The court reporter, of course, there may be a translator, and there will be you and there will be me as your lawyer. I will be present during the entire deposition. The best rule I can give you is to be brief. The other lawyer is not on your side. He or she, they are trying to get information or pin you down on information that they will use later in the case to try to hurt you in your compensation claim. Certainly they're trying to get some information about how the accident happened and what parts of your body are still bothering you and how they bother you. But they're also trying to let you testify to certain things that may be so unbelievable that later when they read them to the judge or ask you about that at the hearing, the judge will also agree that that's so unbelievable that no one can believe that you have either a claim or that you have a certain injury as a result of the claim. Let me go through the little sheet that I've given you. You will be under oath, so everything that you say will be recorded by the court reporter and typed up in a booklet. So those words will be your words. It's very, very important because if you go to hearing and try to say something different than you told in your deposition, the other lawyer will use the deposition to try to explain to the judge that you're giving now two versions of a certain incident or a certain piece of information and that you shouldn't be believed now because you're inconsistent in what you're saying. So it's very important to listen to the question. I will say it again. Listen to the question and only answer the question that's being asked and only answer it briefly. Occasionally, a client is so nervous that they just, right after they say their name, they start talking and talking and talking and talking about where they got hurt and how they don't have any money and it hurts here and they don't have any money to see a doctor and the employer is being unfair, all in a one long breath. That's not helpful testimony because the other lawyer is also evaluating your demeanor and saying, well, gee, this person now does not make a good appearance. He just talks and talks. That's not a good way to start out a deposition or finish a deposition. So listen only to the question that's being asked. Only answer the question with as little information as necessary to respond to that question. You may elaborate only if I want you to elaborate, and I will get a chance at the end of the deposition to ask you some questions and elaborate if I want you to. It's not necessary to elaborate to the other lawyer unless I think it's necessary, because we'll do the elaboration at the hearing. He may or she may have missed a point, a real important point in the deposition, and not asked you about it. Well, that's their problem. It's not your job to answer something he did not ask you. Don't start speaking unless there's a question in front of you. Do not volunteer information. Now, that being said, I will ask you to be courteous and respectful, and don't be arrogant, and don't be angry during the deposition. The other lawyer is only doing their job. Some lawyers are more pleasant than others. Some will try to get you fired up during the deposition to make you say things that you shouldn't say, and that person will then feel like at the hearing they can also fire you up at the hearing, get you angry, and the judge may not like you and then therefore not believe you. So as we go through the little sheet of information that you can use to refresh yourself, remember the court reporter is writing down everything that is said. Unless the parties go off of the record and you step out of the room and ask me some questions or what have you, everything that's being said is being recorded. The purpose of the deposition is so the other side can find out what you're going to say when it goes to hearing, what are the witnesses and perhaps what the witnesses will say, and perhaps what you've told a witness about your accident and how it got reported. Of course, it's very important in Arizona that you have an accident and you report it to a supervisor. So the lawyer may say, well, who did you report it to? When did you report it? And were there any other witnesses present who overheard the conversation of reporting the accident, for example? Because those are witnesses that would be helpful for both parties to know about and perhaps to have at the hearing to either confirm or deny the version of what you've told your supervisor. So that's an example of a question that the other lawyer will ask. They may ask you lots of questions about your medical history and whether you had industrial claims and whether you've had certain kinds of treatment, particularly to the part of the body that is in the workers' compensation case in front of the lawyer. Be very truthful about that. As I explained in one of the introductory tapes in the office, that you may not have recognized that you had a prior workers' compensation claim. You cut your finger, they took you to the hospital, sewed up, and went home. Well, you made a comp claim. You did not realize that, and you think, oh, well, in this case, I've had to fill out lots of paper, I have to go to a deposition, so you think that's the only comp case you've ever had. It's appropriate to say, I think I cut my finger before, I don't know, they took me to the hospital, maybe they made a claim. Don't try to deny claims that the other lawyer tells you about. He may pull out a piece of paper and say, you know, you hurt your knee 5 years ago working for this and this company. Well, if you did, and that's the right person, it's probably true, and certainly agree with it that yes, and whatever. It went away, I got medical care, went back to work, not a problem. Never try to argue and fight with the other lawyer. You will lose every time in the deposition if you think you're going to go in and best him or best her by arguing with him or getting contentious. Again, remember, they are evaluating whether or not you're going to be a pleasant person in front of the judge. Pay attention to your physical appearance. This is an important matter. You don't have to wear a suit and tie, but dress appropriately. Dress in a fashion that's clean and respectful in terms of your appearance as you go to the deposition. Speak very, very slowly and very clearly. Court reporters are well trained and they can take down people that speak fast, but it's difficult for them to take down people that speak very, very fast. Sometimes when people are nervous, they speak faster than they should. So just take a couple of deep breaths and calm down. What I tell people is when you hear a question, take a deep breath, because you can't start talking while you're taking a breath in. And the breath will help you relax, you'll calm down, and you'll answer the question more accurately and perhaps truthfully and without talking so fast. So take a breath in, think about your answer, and answer it accurately and concisely. Be very, very brief. Always tell the truth. If you don't tell the truth, you will be impeached later as you go to a hearing. Many questions are going to be asked, and they may not be admissible as we go down to the industrial hearing. But they're going to ask questions about your background, your education. That may help them determine whether or not you understand certain questions. For example, they'll ask you about the extent of your education, because part of the case may involve filling out forms reporting the accident. If you don't read or write, then obviously you wouldn't fill out the form correctly, or even fill out the form at all, or even understand that there was a form. So you may think, well, why did he ask that question? It's not your job to try to figure out what the lawyer wants as the answer to the question. You just figure out what is the answer to the question. If you know something, you can say you know it. If you don't know it, it's important to say, I don't know it. Some lawyers are very, very congenial people, and they will try to get information out of you, and you think, well, gee, he is such a nice guy, I'll just keep talking and talking and give him whatever he wants. And that's how they get you to say things that does not help your case. You then say more than you should because, gee, he's a nice fellow and you want to please him. It's not your job to please him. It's your job to simply give information and answer it very briefly and then simply go home. And, don't volunteer any information or facts that are not requested. Don't pull things out of your pocket and reach for your Social Security card, your driver's license, anything like that, unless you ask me first whether you should do that. And anything you're going to show the other lawyer, you have to give to me first before you give it over to him, so that I ensure that it's done properly. If you don't remember a doctor's name, for example, that's okay. The lawyer may be more interested in just the progress of the claim and the chronology and what doctor you went to first and second and third. He or she may not want to know specifically what day. If you don't know what day, don't guess. If you know it was within a week of the accident, well, then you can say it was approximately a week of the accident I first went to a doctor. We will go over a lot of that in your deposition preparation, but don't guess as to dates and times and things of that nature, because typically you will guess wrong. If it is a week, say a week. If it's a couple of weeks, it's a couple of weeks. But there's a big difference between a couple of weeks and a couple of months, so don't get caught in simply throwing out dates and times that you can't substantiate from the actual medical records themselves. Never try to memorize what you're going to say, but remember to listen to the question and then answer only that question. Don't, again, volunteer. I've said that several times, and it's very, very important. Stop talking. Don't talk too much. People say to me after, how do I do? And I said, you didn't follow any advice that I gave you. You did not shut up. All you did was talk and talk and talk and talk. It's not your time to try to sell your case to the other lawyer. The other lawyer works for an insurance company. He doesn't believe you got hurt, doesn't believe you got hurt badly. They're, to some degree, insulated, they're a little callous, and they don't represent injured workers. So all they do is represent insurance companies, so they believe whatever the insurance company tells them. They may have information in their file that the adjuster has told them that, oh, you got hurt on a weekend riding a Jeep into the mountains. Well, that may not be true, but he may ask you about that, so don't get angry over that they're getting information from a variety of sources. But simply listen to the question and only answer the question that he asked you, and don't get mad at the question or where he's going with the question. Don't try to figure out the answer that he wants. Figure out the answer that is accurate, brief, and true. Otherwise, you're going to have some problems when we go to the hearing, and that person will bring out that deposition and show that you are being inconsistent. If I start speaking or objecting, don't continue answering until I finish my objection. Many times when I give the objection, I'll be hinting at what I think is wrong. I'm objecting. That witness doesn't know. It's speculation. How would that person know what's in the mind of the supervisor? And then you can take that as a cue, and when you go back and answer and say, oh, I don't know what the boss was thinking about it. I don't know whether he filled out the form or not. You're only asked to testify about what you know and what you see. If you saw the boss fill out an accident report form, then you can testify to that. If the boss said to you, I'm going in the office and fill it out, then you can say, well, the boss only told me he was going in and going into the office to fill it out. Whether he filled it out, I don't know. I never saw a copy. So don't try to speculate. Don't try to fill in the gaps. Don't try to give an explanation and explain everything. It simply is just not going to work in a deposition if you do that. One of the things that I want you to remind yourself in the deposition, and it's good for the hearing as well, you have to show the judge where you were hurt. If you say, for example, and your left wrist hurts from the accident, and you point to your left wrist and say, the other lawyer will say in the question, where did you hurt yourself? And you say, I hurt myself here, and then the pain goes here, and the pain goes here. The court reporter will write down in the book, here, here, and goes here. She will not write down left wrist. She will not write left elbow or left shoulder. You and I have to explain that. So I might interrupt you and say, hold on, Mr. Claimant. You're showing the court reporter your left wrist, your left elbow, and your left shoulder. And you will look at me like I'm crazy because you're sitting there doing that. I always say, pretend the court reporter's blind. So she can't see where you're pointing to. You have to tell us in words that make some sense to her. My left wrist hurts, it's my left elbow, and goes all the way up into my left shoulder. When you do the hearing with the judge, you will have to do the same thing. And when you point to parts of your body, do not be a doctor. You may have heard from all of your physicians the medical terms about the part of the body that hurts you. Do the best you can not to use the medical term. Do the best to tell the judge in everyday words where it hurts. My back hurts. My back hurts 4 inches or 1 fist length above my belt. My back hurts below my belt in the center of my back. You see, I'm explaining where I just touched. The judge can't see that. Even if you turn around and touch it like you would in a deposition, the judge still, in his court reporter, still has the same problem. You will have to show them and tell them where you're showing. For example, you would then say, the pain hurts me in the center of my back, goes all the way down below my belt, 5 or 6 inches into my butt, and goes all the way down my right leg if it goes down to my right leg, and it goes all the way down to my knee or down to my ankle. Use parts of your clothing. It hurts me here around the collar of my shirt on my neck. Don't say it hurts me at C2, C3, C4. That demonstrates to the judge that you're kind of getting off on your injury and you're not trying to explain your injury. You're trying to revel in your injury, and I don't think that's always helpful. I think it's just best to be a common person to explain like you would explain to your neighbor. It hurts me here, right around where the collar of my neck is or where my hairline is, and the pain goes all the way up my head to my forehead. 2 inches down from my hairline. That's how you would explain things. You show them and then you tell them that. Use words that you would use in telling your friends. It goes down the seam of my pants on my jeans. The pain goes all the way down the outside seam of my pants. Not the pain radiates. That's a doctor's word. You learned that because your doctor told you that or you read the medical records. I think you become less believable when you tell judges medical terms. You didn't know those medical terms before you went into the industrial claim, so don't use them. Just simply use terms that make some sense in chosen words that are simple words. Don't try to talk like a lawyer and use big words. All we're trying to do is explain your claim to the judge. When you go to the hearing, as much as you go to the deposition, You are painting a picture of what happened and where it happened on your body. So use the parts of your shirt, your skirt, your jeans, what have you. Use words like on the outside of my foot, on the inside of my foot, on the outside of my leg, on the inside of my leg, my pain. It's severe. It is throbbing. It is dull. Those are the words you can use. Many times in these depositions, they'll ask you to rate your pain on a severity of 0 to 10. And many times they will try to trick you in a deposition by saying, so you're telling me that your pain now is a 10, meaning the worst it's ever been, and now it's a 10, and it was a 10 the day you got hurt, and you've had 2 surgeries, you've been to 5 doctors, and you haven't gotten any better, and you're still as bad as you were the day you were hurt. Very, very rare cases of those situations. But you're going to fall into the trap to try to agree with the lawyer and say, yeah, oh yeah, I'm really badly hurt, because you think the more you tell him you're hurt, the more he's going to believe you. It actually works the opposite way. The more you tell him you're hurt, the less he's going to believe you, because he doesn't believe that anybody could be hurt from an industrial claim to start out with. So always try to be precise in where you're explaining. And watch out in the deposition for the lawyer trying to throw words that you will put in your mouth. If your left ankle is part of the claim, and he says to you the pain goes all the way up your left leg, isn't that right? Yeah, and then it goes across your back, yeah, and then it goes down into your right leg and all the way down to your right foot, he's tricking you. And don't fall for that. That doesn't happen too often with the lawyers, but it happens enough that I have to tell you in the deposition, watch out for that. Watch out for key words when the other lawyer says, you would agree with me that. Don't you agree about this? If you don't agree, it's okay to say, I don't agree. But don't fall into the trap and agree with him just for the sake of giving an answer to him to get out of the deposition. A lot of folks are so scared of the depositions, they just say anything that comes to their mind to get out of the room, and then they say to me later, I wasn't thinking, I wasn't paying any attention, I just wanted to get out of there so fast. Well, you've done your case a disservice by doing that, because that testimony will be used against you when you go to the hearing if you have said something that's so bad and so wrong that it's going to affect your claim later. I will tell you the other lawyer is going to use it against you. So be very, very careful in how you handle those kind of do you agree with me questions. If you don't agree, just be respectful and don't agree. Say, no, my back hurts and it hasn't gone away. Watch the extremes. It may be a 10 at times. It may be a 6, but on your worst day, it may be a 10. But it very likely is not a 10 in pain every day after you've had several surgeries, unless you've had a terrible, terrible result from your doctor. Don't guess. You know, people try to guess about distances and things of that nature, and they get into some difficulties. Well, I would suggest that if you, for example, if someone asks you how far was one object from the other object at the site where you got hurt, you say, you know, I really don't know. My best estimate is 10 yards, but if I ever went back out there and paced it off, I'd have an absolute accurate number. And then what I would have you do is, before we go to the hearing, I would have you go out and pace it off at the construction site so you would know exactly how far item A was from item B, if that's important in your claim. And then if he says to you, well, hey, you said at the deposition you didn't know, and you say, yes, but I went out to the accident site and I paced it out, and now I know exactly how far it was. It's 10 steps or 10 yards. So that's one way to kind of make sure that you don't guess. You always have a right in the deposition to take a break and confer with me. If you think you need a break, just say you'd like to use the restroom. They'll let you use the restroom, and at that time you and I can talk about it. I can't help you with your answers during the deposition, which is the reason that we're having some preparation. Generally, before the deposition, I will tell you, well, the other side is going to say that you didn't report the accident right away. And so we'll know a few of their defenses. Or the other side will say, well, they're going to claim that your back was not hurt in this accident, it was hurt on the weekend. Or, gee, it wasn't hurt in this accident, it's the same back problem you had 10 years ago in another accident. So be very careful about what you use in the choice of words. Never say the word never unless that means not ever. For example, I had people say, I never, never, never pick up a gallon of milk. I have so much pain in my arms and my back. I never go shopping, never pick up a gallon of milk. The insurance company will then go out and attempt to get you on a videotape where they'll see you in the store picking up a gallon of milk. And they will take that never word and stick it up your nose. And I will tell you that if they show you that movie to the judge will not believe you, and your case will just go down the drain. So you're not there to exaggerate your claim. You're there to accurately, briefly, concisely express your claim and explain your claim. If you try to exaggerate it, you will get caught in the exaggeration. I never pick up the milk. That's a red flag for the insurance company to go simply out and try to catch you on a videotape, shopping, doing more than you have said. I never pick up 50 pounds, and the next thing you know, they have you mowing the lawn and picking up things. They will always, always find a videotape on you when you're in the backyard or the front yard, but not when you're lying down on the couch after, yes, I cut the grass and I had to lie down for 2 hours afterwards because my back bothered me so much. Remember that when the lawyer starts asking you questions about did you do this or did you do that, there might be a videotape out there that is going to question your believability and your veracity. I think you can say, yeah, I cut my own grass, or I do my yard work because I have to keep the house up a little bit. But after I did that yard work, I simply had to go lie down. I tell people if you have some problems with your back and you're cutting your grass, lie down on the grass. They will never show the movie then if you're simply resting and reclining in the backyard after you did 5 or 15 minutes worth of work, and now you have a problem from that. They will never use the video to show that you have a problem. So be careful about the word never or not ever. People get trapped in that word. Or always. I always use my cane. I always use my walker. I always have the knee wrap. That's just an invitation for them to catch you without those items on your body. So simply say, well, most of the time I do it. And be careful that always means all the time, and never means not ever. Relax. As hard as that is for me to convince you of that, you should relax. But don't relax to the extent that you're going to fall in the trap of, well, you know, I'm going along pretty well with this. Let me just say everything that I want to say. I will give you an example. I had a lady that testified for hours that she never, ever had a back problem. She would put gravel down on her house because her husband traveled a lot, and she did all the yard work. She testified for that for hours at the deposition, at the hearing. My last question to her was, so you've never had any problems like this until you did this act that is the workers' comp claim. She looked at me and said, oh, no, I've had those problems before, which was contrary to everything she said. And later, when her husband practically fell off the chair and we lost the case, he said to her, why did you say that? She goes, well, I don't know. I was just getting kind of comfortable there, and I was kind of relaxed in the hearing, and it just jumped out of my mouth. And as soon as it came out of my mouth, I knew it was the wrong thing to say. That's what happens in the depositions when you relax too much. But my point is relax enough so that you're not giving just abrupt answers because you want to get out of the room and you're afraid of the other lawyer. My job is to protect you from him. Don't worry about that. I will do the best I can. Now, there's a lot of congeniality in the workers' compensation bar. It is a small bar, so I know most of the lawyers, and I can tell you about their personalities ahead of time. I will tell you whether they take a long deposition. I will tell you whether they take an abrupt deposition, whether they're going to try to be mean to you. I will give you that information before we go over to the deposition. So don't think it's going to be like television. It's not. Everything you have seen on television, forget. The depositions are not like television, nor are the hearings like television. That you have to be careful in a deposition, and the best way is to listen, be brief, be concise, and only answer the question that's in front of you. It will give you preparation for the hearing. I will, at the end of the deposition, if I think questions need to be cleared up, I will clear them up. And when I give you information, you should agree with me. If I say, well, you did go to a chiropractor a few years before and his name was Chiropractor Jones, I'm throwing you an easy pitch, and you should say yes. I wouldn't ask you that question unless I wanted you to say yes to it. So generally, anything I ask you at the end, you're going to elaborate in a positive way. Yes, I did go to a doctor. Yes, I had prior industrial claims. Yes, I had a prior back problem. Is the problem you have now the same as the back you had before? No, it's a different part of my body, or it's more severe, or I get the pain more frequently. I'm giving you a chance to hit the easy pitches at that point. Now, at the end of the deposition, the court reporter will want to know whether we want you to sign that deposition and whether we want to purchase the deposition. Rarely will I have you sign the deposition unless it's so chopped up during the deposition. And I will probably not ever purchase a copy of the deposition because you will have to reimburse me for the copying of that deposition, buying the copy of the deposition. The other rule that I'm going to give you in any deposition, and I'm giving it at the end of the explanation so that you can remember it, is that it's not like a normal conversation, even though I want you to be relaxed. It's like talking on the radio or on the telephone. Two people can't talk at the same time. So when the other lawyer asks you a question, think of him hitting a ball over a tennis or a ping pong net. You're to hit that ball back. Don't swing at it before it's in front of you. Don't try to hit it before you get it. Only answer the question, but let him finish the question before you answer it. You're going to know most of the questions. If he says, well, where did you work before? And you're already thinking he means before I went to work for this employer, you're already starting to give him your prior work history. Wait till he says before this job. Let him finish the question and then answer it. Because that's the same thing at the hearing, and the judges get very, very irritated because they're trying to protect their court reporter from people talking over each other. Anytime you want to give an answer, you must give that answer out loud. You can't say no by shaking your head left and right. You can't say yes by going up and down. If you want to say yes, you say yes. If you want to say no, say no. And it's better to say yes or no instead of yeah or nah. You know, that's not a real respectful way to answer a question. And if you get into the rhythm of answering it that way in a deposition, you're likely to do it that same way at a hearing. But answer out loud. Don't say, things like that. It's hard to remember that. You will make those mistakes during the deposition. The court reporter might question you and say, was that a yes? Was that a... And you'll say, oh, yeah, I really meant to do that. I meant to say something out loud. It's not a normal conversation, so people do make mistakes like that. But just try to think through it and just take a deep breath, answer the question out loud, answer it with words, and you'll do fine with the court reporter. If someone hands you a document, you want to read the document before you start to answer questions about it. Or if he doesn't hand you the document, then say, I got to see the document before I can answer a question about it. It might be an accident report form or maybe a statement that you took about how the incident occurred. Well, don't start answering a question about a document until you've had a chance to look at it and say, I'd like to take a minute or two and read it, and we'll take a break and read it. Those are some of the tips that I'm going to give you in a deposition, and I think you'll do well if you follow those rules. They want to find out about your case. That's all they want to find out about. They also perhaps may want to trick you into some concessions that you need not make. And don't make a concession unless you believe you can do that. One question they always ask is, well, what do you think you can do with all these permanent problems from your injury? Do you think you can be a parking lot attendant? And you don't say yes until the best answer is, well, I would like to try that consistent with what my doctor tells me my limitations are. There are ways you can turn their question back to be a more favorable answer for you, and I will talk to you about those with respect to the particular issue in your case. But this is a deposition tape to just give you some general information about the deposition. If you have questions, ask me. Always remain calm. Always be polite. Do not try to fight with the other lawyer during the deposition. You'll just lose each time. And there may be more than one lawyer in the case if there's multiple claims or multiple employers. They each get a chance to ask you questions, and some will ask better questions than some others. If you don't understand the question, you can say, I don't understand the question. I didn't hear the question. Would you read it back to me? Would you repeat it to me? You have control over the deposition. But you also can ruin your case at the deposition by not following the rules that I've given you on this tape up to this point. If you have any doubts whatsoever, I want you to write them down on the sheet of paper that you have in front of you or in your folder and ask me about specific things before the deposition. You will do well at the deposition if you follow these rules, and I'm going to ask you to think about the rules, finish looking at this tape, and I'll be in a moment or two to tell you what is specific to your case. Thank you very much.